Good day. Today, I want to talk about the number one thing that jurors want and expect. I've had the privilege to talk to dozens and dozens of jurors after my trials. And a lot of times the jurors like to circle back and they want to know why they were picked, or they'll have other questions about the trial. But without question, the number one complaint that jurors have is that the trials waste time, take too long, involve repetitive questioning, and involve issues that don't get to the heart of the situation. After I was no longer a prosecutor, I was asked what was going to happen in the OJ criminal trial. And I said the prosecutors were going to lose. They put on a case for months and months with completely irrelevant witnesses and irrelevant evidence, angering the juror in the thing that they value most, which is their time. The most effective closing argument requires that an advocate make a commitment to the advocate and to the jury from the very beginning of the case. And the most effective closing argument is that, notwithstanding that there are some slip-ups, that I have endeavored to get to the point and to be the most respectful of your time. So now, how are we going to decide the case? Here's the law, and here are the facts that address that decision. When you're questioning a witness, a lot of attorneys have a preset notebook and they can't get out of their own way. They waste time, ask repetitive questions, and don't get to the point. And there's something called the Pomodoro rule, which is that focus really goes forward in 25 minutes. And having cross-examined hundreds and hundreds of individuals, I can say for a fact that if you haven't drawn blood in the first 25 minutes, the jury is already turned off and thinking about other things. Second, with respect to the jury, you want to know where the rubber is going to hit the road. You want to know what the key facts are, and you want to win those facts. And finally, you want to have credibility, both yourself and your witnesses. And even though it's theoretically possible for your client to be the liar in the case and have a jury get around that, that's true in theory. I've never seen it actually happen in practice. John Belcher.